This is Katrin with Disability Rights New York. Welcome to our podcast, Empire State of Rights, where we bring you information on the most relevant topics regarding disability rights and advocacy. Today, we welcome DRNY Senior Staff Attorney Jessica Richwalder. She's here to discuss work from home as a reasonable accommodation, how to submit a request to your employer, and the steps needed to file a complaint if your request is denied. Hi, Jessica. Thank you for joining us today.
Thank you so much for having me. I'm really looking forward to our discussion.
I am too. And let's start by talking about what a reasonable accommodation is when it comes to employment.
Sure, that's the basics here. So put simply, a reasonable accommodation is a change to a person with a disability's job that would allow them to fully perform their job. So in a little more detail, the Americans with Disabilities Act, also known as the ADA, requires that employers provide reasonable accommodations to employees with disabilities to allow them to perform the full scope of their job. Accommodations are specific to each person, so what the accommodation is will vary from person to person.
And how does work from home qualify as an accommodation now? We have a lot of people who have been working from home for about 3 years. And now to think of it in different terms, what does that mean? Who's going to qualify for that now?
So working from home might qualify as a reasonable accommodation if a person can do their entire job from home and no part of their job is compromised by not being on site, whether that's in an office or out in the community somewhere. So it's a change to the standard in many jobs that a person has to work from their office or a specific location that's not their home. But that said, employers are generally provided a lot of latitude in determining whether it is necessary for a person to do their job in person at an office instead of remotely. And there is no hard and fast rule that a person with a disability is entitled to work from home. And there's also no hard and fast rule that a person can't work from home if they can actually do their job remotely.
So it sounds like this isn't really a straight shot, that there's no check these boxes and it's a yes, and check these boxes and it's a no. So if someone's thinking about filling out a request to work from home as an accommodation, what should they be looking at? Are there any general rules or guidelines people should be considering before they even start to fill out the request?
So generally when DRNY is evaluating a work from home request and advising someone on whether we think the request is a strong request or might have some gaps that might lead to it being denied, there are a few things that we typically consider. And these are things that we would encourage a person with a disability to keep in mind when they're considering if their own work from home request might be a reasonable accommodation. So aside from being a person with a disability, the first thing we look at is if there is any aspect of the person's job that cannot be performed from home. If there is, then it's very likely that the employer has a strong argument that that person needs to be in the office or whatever else the work site is. And even if that person's job was changed during the COVID-19 pandemic and the period of lockdown to remove a certain aspect of the job, it is very well settled law that an employee must be able to perform all aspects of their job. So if from your perspective, there's no aspect of your job that you can't do from home, it can be helpful to directly ask your employer which tasks of your job require you to be in office, if they are indeed saying, we really need you in the office to do your whole job. And while this doesn't always work, some employers realize when they can't articulate a reason that a person needs to be there, that maybe they can work something out with the employee to allow them to work from home.
And just let me ask you something. So there's what you said is, if you're evaluating your job and there are things that you feel like everything can be done at home, is it often the case that the employer may disagree? Or maybe if it's not even often the case, it's possible, right, that the employer may have a different idea on whether or not all of those things could be performed at home?
Yes, absolutely. We're still seeing a lot of industries and employers who really hold on to the idea of being in the office. And I think that's kind of a cultural shift that employment and the workforce is seeing. And so there's some resistance to it. And requesting to work from home is not something new that was created by COVID-19 or the lockdowns, but it is something that a lot of industries and employers realized is a realistic option. So it's led to a lot more conversations, and in sometimes more difficult conversations, because it is hard for an employer to tell someone, we can't let you work from home anymore, when they were doing their whole job from home for a year or 2 years. And so we're seeing a shift, but it's not, like I said in the beginning, it's not an entitlement necessarily for people with disabilities.
I think that's one of the things that we hear about in conversation a lot, right? There was at least one full year, if not two, where truly globally we were at home working, and if we didn't, industries just would not have continued to exist. So, as you said, this is not a new request to work from home. It is a little bit different now, though, because we have seen that jobs have been able to be performed, and now maybe maybe argument isn't the right word, or disagreement on whether or not that could continue really looks a little bit different. And I think that might lead us to talking about hybrid work schedules. How does that figure in?
So the second thing that we do ask people to consider is if a hybrid work schedule might accommodate their disability. We find that asking for a hybrid work schedule, so where you work from the office or on site some days a week and from home or remotely other days a week, tends to be a lot more palatable to employers who are resistant to remote work. And so they're often more willing to work with and kind of be flexible with an employee if they're showing up at the office at least some days some days a week. So it may be helpful to propose a hybrid schedule, and that doesn't necessarily mean that it needs to be set. It doesn't necessarily need to be you'll be in the office every Monday and Wednesday and Friday, and you'll work from home on Tuesdays and Thursdays. And we often actually see with people with disabilities that they are looking for a hybrid accommodation when they can work from home when their disability necessitates that. If they have symptoms that flare up, if it's impacted by weather, if their disability impacts their ability to access transportation to the office, then those are a lot of things that the employer and the employee can discuss to try to reach a balance of meeting the employer's need or sometimes just desire to have people in the office, and the employees need to be able to work from home to mitigate the symptoms of their disability.
And so are there other parts of that conversation that can take place, like whether or not there are things that can be done in the office that maybe weren't done previously to really help facilitate more of an effective or balanced, as you said, accommodation for being able to get your work done and have the employee, or the employer rather, feel like everything is getting done?
Absolutely. And so when we're talking about work from home as a reasonable accommodation, we should remember that it is one option in a vast and almost infinite world of reasonable accommodations. And so if it's really truly not an option for a person to work from home either full time or on a hybrid schedule, then you should absolutely discuss with your employer what accommodations they can provide you in office to allow you to work there. And it's important to remember that an employer is not required to provide the reasonable accommodation that a person asks for. They're required to provide one that is effective. So it needs to be a dialogue with you and the employer. So you can consider accommodations in the office that might help, like a designated office space with a door, particular lighting, maybe flexible hours, help you be able to commute and get to the office better, air purifiers, noise canceling headphones, assistive technology. The list is really endless, but we do really encourage people to be open to those ideas, especially if, when we go back to that first question, can your whole job be performed at home? If the answer is no, then you really might need to look at accommodations in office or on site that'll help you be able to do your job.
And as you said, this is really a conversation, right? Trying to find the balance, find a way that your needs can be met. And as you're talking about filling out the request, and even if these conversations have been in the very beginning or even thinking about it, What information should someone be looking for and making sure that they have before they put together that request? Are there best practices that we can talk about?
Absolutely. So the first rule, the first best practice is that we always recommend that someone submits a reasonable accommodation request in writing. There is no universal form or magic language or anything like that that you need to use. But whatever you come up with to send either via email or regular mail or interoffice memo, you should keep a copy of that for yourself, just so you have a record of everything. And the request should identify your disability, what it is. It should state the accommodation that you're requesting. And then the letter should explain the connection between those two things. So for example, a request could be something as simple as saying, I have cancer, which makes me immune compromised. I'm requesting to work from home to reduce the risk of contracting COVID-19 or other communicable diseases which pose a significant risk to my health. So it's fairly simple, and you don't necessarily need to go into a ton of detail, but you do need to, like I said, identify the disability. You should identify the accommodation, though. If you just kind of generally say that you need something, then the employer is required to engage in that dialogue. And then again, explain the connection between what you're requesting and your disability if it's not already very, very obvious.
Is there a time frame someone should be looking at? Like, in general, does this happen very quickly? Or should you ask for a certain amount of time, to have your response?
So there's no hard and fast rule about how quickly they need to respond. It all falls under the umbrella of reasonableness, which can be a little frustrating. But you should make the request to either your immediate supervisor, or we would also suggest that someone check out their employee handbook to see if there's someone specifically designated, like an HR supervisor, to take this type of request. And in your request, we'd recommend asking for a response in 1 to 2 weeks, or at least asking for acknowledgement that they've received and are considering your request in that amount of time. And if the employer responds to you verbally, we would recommend that you request that they follow up in writing. And if they decline to do that, then you can create a record by sending a follow-up email that memorializes the conversation. So something along the lines of, I'm writing to memorialize the conversation we had earlier today, where you denied my request to work from home for ABC reasons. And then in that, I would invite them to continue to have that dialogue with you, because again, it really is required that there be some back and forth in the discussion.
And what about if there's someone who is looking for an accommodation and maybe to their employer, their disability may not be obvious. What do we do then?
So an employer is entitled to ask for medical documentation of your disability unless it is very, very obvious. And by very, very obvious, I mean, if you're asking for a ramp at work and you're a wheelchair user, the employer is not entitled to ask for documentation that you use a wheelchair. But many disabilities are invisible disabilities, and so an employer is entitled to ask for a basic letter from your medical provider stating that you have that disability, that they recommend the accommodation that you're requesting. And again, usually that would explain the relationship between the disability and the accommodation. The employer is not entitled to your entire medical record. They're not necessarily entitled to speak to your medical provider directly. They're just entitled to enough information to essentially prove to them that you are a person with a disability and that this would be a reasonable accommodation.
And it sounds like one of the biggest keys here, again, is communication, right? Having all of your information, if you need documentation, making sure that it's available, and of course, keeping a record of these conversations. And I think it's both a benefit to you and to your employer. And Jess, let me ask you quickly, what if something changes, right? So say you have a request and then maybe your request needs to change. Do you need to fill out another request, or can you amend at some point?
So if the request is still pending, then I would say that it's okay to update it if you haven't received an answer yet. If you've been working under the original accommodation that you requested or discussing that specifically with your employer, then I would amend and update them on the situation. Just like reasonable accommodations depend on person to person, they're not necessarily permanent in any context. So what is reasonable for an employer at one point might become unreasonable at another point. And the COVID-19 pandemic and the lockdown is a perfect example of that. For a period of time there, it was very reasonable that everyone had to work from home. And like I mentioned, some parts of jobs might have been changed to accommodate that. And then it became less and less reasonable for everyone necessarily to be at home. So an accommodation being granted is not necessarily an indefinite answer about things. And so it's always a conversation and a dialogue. A lot of employers will have work from home or other accommodations be for certain set periods of time and reevaluate them regularly. And that's definitely something that the law allows. And again, the employer can choose among the different reasonable accommodations as long as what they're offering is effective in actually providing access to the person with the disability. Generally, the rule is that if an accommodation is not effective, that it's not reasonable. But again, those words can have different meanings to different people, so it can be tough to give a black and white answer.
And so say you've filled out your request form, you've had all your documentation, and still you get this accommodation denied by your employer. What do we do then? Are there agencies that can offer assistance? Is there something else that a person can do to try and get this accommodation done?
Absolutely. So people generally have a few options depending on where they live, because there's just different jurisdictions. So anyone in the United States, regardless of where they live, can file a complaint of employment discrimination with the United States the United States Equal Employment Opportunity Commission, which is known as the EEOC. They are the agency that enforces the ADA. So a person cannot go to federal court on an employment discrimination claim without first filing with the EEOC. But the EEOC also has its own process where you might never need to go to court, but could still resolve the problem. And that complaint would have to be filed within 300 days of the accommodation request being denied. And similarly, people who live in New York State can file a very similar claim with the New York State Division of Human Rights. They are the agency that enforces the New York State Human Rights Law, which is essentially our state version of the ADA, and provides almost identical protections to people with disabilities. And that complaint needs to be filed within a year, so you have a little bit more time in that situation. And lastly, if a person lives or works in New York City, then they can file a claim with the New York City Commission on Human Rights, and they enforce New York City's human rights law, which is, again, just the more localized version of the ADA. And that human rights law actually provides some extra protections on top of what the state and the federal protections provide. So if you live or work in New York City, we would definitely encourage you to look into that option first, because you might have a stronger claim there just because the law is a little bit more favorable. And that also has a 1-year deadline from the date when the accommodation is denied or any other type of discrimination takes place.
So it sounds like there are definitely avenues that someone can pursue if for some reason their accommodation gets denied.
Absolutely. So there's all those administrative agencies. A person can also go to state court with their claim, but that is much more difficult and complicated to do without an attorney, which finding an attorney we know can be prohibitive for people in a lot of different ways. And the administrative agencies that I mentioned above, the EEOC, the New York State Division on Human Rights, and the New York City Commission on Human Rights, are better equipped to handle a claim directly from a non-attorney, and that process is a bit more non-attorney friendly than the court process. And you do also need to choose just one of these avenues to pursue. You can't file a complaint with them all at once and hope one of them works out best.
I think that's really good information. Oftentimes, when we think of whether it's a complaint or we feel like we need to take action, it's let's fill out all of the forms and let's complain and and file things everywhere. And that can also not work well for you. You need to just do one in this case. And I think that's really great for people to know, because oftentimes we want to do everything to get things moving. And so when we talk about the amount of time we have to file, right? So we have almost a year, and then a full year on state, I think is what you said. And so what happens then? Like, then how long does the process generally take?
So unfortunately, this is not going to be what people want to hear, but any complaint, whether it's administrative or the person, gets an attorney and chooses to go to court, it's likely to take a long time. And I always tell anyone considering filing a complaint, whether administrative or in court, that you should expect at least a 2 to 5 year process to come to some type of resolution. That can be shorter or that can be longer, depending on an infinite number of factors. But generally, we tell people to expect to be in it for the long haul. But the positive side of it is that the process is fairly simple. So the employee, the person with the disability, would file a complaint and send it to the agency. Some of these agencies have forms, others you can just write a letter and describe what happened. And then the agency will send a copy of that to the employer. The employer gets to respond. The employee then gets the final say in things in writing, and then the agency will investigate. And typically that is the agency asking some questions, clarifying points. They'll usually interview the person who filed the complaint over the phone, where they'll ask you what happened, how it made you feel, how it impacted you, if you know of any witnesses or anyone else who was treated differently. And it's really just a conversation about what you went through, so they can decide if there was discrimination that potentially violated the law.
They really want to find out what's happening. This is really taking your words from the form, and they want to hear also. I really liked hearing from you that they want to know how it made you feel, because of course you can't necessarily get all of that out into a form or have someone read it and understand how something has impacted you.
Right. And so it's about getting the full picture of what happened. And oftentimes the employee and the employer will tell a bit of a different story, which is why, going back to when we said everything should be in writing, it's important to document as much as you can, so that if you say, hey, I asked for a reasonable accommodation on May 1st, and the employer says, no, they didn't. If you have a copy of that in writing, then you can show that you did. And that also boosts your reliability and the agency's belief in what you're telling them. And so that can be really helpful. And even something as simple as handwritten notes or a log that you keep on your computer that says, I followed up and asked HR about my accommodation request on this day by phone, and just having some type of record to be able to share with the investigator to show them what you were trying to do and to accomplish can be really helpful in demonstrating to them that you were putting forth your best faith effort in trying to make things happen.
And so after the investigation, what happens from there? How do we get to the point of resolution, and who resolves this?
So the agency, right after the investigation, will make a decision about whether it seems likely that there might have been discrimination, or if it seems like there probably wasn't. And so if it seems to the investigators that there probably wasn't any discrimination, then the case is closed at that point, and that's really the end of the process. But if it does seem to them like there is some type of discrimination, then the case would go to a hearing, which is kind of like a trial, and the agency would usually assign at that point an attorney to work with the person with the disability, the employee, through the rest of the process and through the hearing process. But also, at any point from the time that the employer gets notice that the complaint has been filed, all the way up until the moment before a judge or someone else would make a decision about the case, the employer and the employee can agree to resolve things without continuing the complaint process. This is generally called a settlement or a conciliation, and it's a negotiation where both parties come to a mutual agreement. And so that usually involves both parties giving a little, whether it's changing exactly what they were asking for or admitting to something that they didn't want to admit to before, there's usually some give and take. And the positive of that is that you get to have control over the outcome, as opposed to if a judge or a third party is making the decision for you, that decision is completely up to them, which can be a little hard to accept sometimes.
And so DRNY must get a lot of questions regarding the work from home accommodation. What are some of the common questions that we receive and that we're able to help people with?
So DRNY does help a lot of people work through whether they have a good basis for a request to work from home or not. So that goes back to those questions about whether you can do your whole job from home, whether a hybrid schedule or some accommodations in the office might work for you, and just helping people think through the requests that they're going to make, and also helping people make the strongest request possible. It's not always a black and white process, as you might have figured out by now, but having an opportunity to talk to an expert in this area can be really helpful in figuring out the strength of your request. And DRNY will also often be asked if there are certain jobs where they must let someone work from home, and the answer is no, because it's always an individual assessment of the situation. And similar to that, we also get asked if there are specific disabilities that would always qualify someone to work from home. And again, the answer is no, it's always on a case-by-case basis. So lately, we've been seeing a lot of people who are immune compromised, who are requesting to work from home to reduce exposure, or people with limitations that might make commuting difficult. But again, neither of those things guarantee a work from home accommodation.
And so let's just for a minute talk about temporary disabilities. We've talked about if things change in your request process, but also temporary disabilities, and even something that many people may not even consider to be a temporary disability, like pregnancy, for instance. How does that work? Are there differences in this type of work from home accommodation? And are there different things to consider when filling out that request?
That's a great question. So the ADA does not necessarily require that a disability be permanent, nor that the accommodations for a disability be indefinite. So like you mentioned, pregnancy, cancer, or other treatable or term limited conditions or illnesses will often fall under this, and they can qualify as disabilities under the ADA, meaning that a person can then qualify for reasonable accommodations. That said, the process is the same as what we've discussed today. You want to make your request in writing. You may be required to document that you have that condition. And then there'll likely be some extra questions about how long it's likely to last and what term of the accommodation you might need. And that might involve a more in-depth conversation with your doctor than other types of accommodations might, just because an employer will likely want to see a professional opinion from your doctor about how long this is likely to impact you as a disability and how long you're likely to need the accommodation. Now, those things can obviously change, and so it can always be in flux, but as long as you're being truthful and putting forth your best effort to provide the accurate information, then you're doing everything right. And we have seen that employers are more open to work from home if the time period is limited. So that's something to consider as well, is if you only need to request to work from home for a certain period of time, or maybe you want to request to work from home for the winter period when more communicable diseases are going around, then that's something that you can ask for too. And we like people to be, creative and flexible when they're thinking about their accommodation requests.
And if people have questions that they just want to do research, does DRNY have some resources for people who have additional questions about reasonable accommodations?
Absolutely. So far and away, our best resource is our attorneys and our advocates. And so if you want to request to work from home or another accommodation, or you've already made that request and it's been denied, you can contact DRNY to speak to someone with experience and expertise about this, about the strength of your request and how you might be able to improve it. We can also offer template letters and other technical assistance to help you really maximize the potential of your request. And then we also have some really great fact sheets on working from home and reasonable accommodations that are available on our website.
And we will be sure to put those fact sheet links in the notes of the podcast. And Jessica, before we sign off, is there anything else that you would like to talk to our audience about today?
I think I'd just like to remind everyone of what I've been trying to, pepper in throughout this entire conversation, is that we really want everyone to keep in mind that there is no one size fits all scenario with reasonable accommodations. And so we encourage you to try to be flexible and creative and open when thinking about having that conversation with your employer and how to make things work effectively for both you and for your employer.
Jessica, thank you so much for your time today. We look forward to talking with you again.
Thank you so much for highlighting this important topic.
Empire State of Rights has been brought to you by Disability Rights New York, your source for disability rights and advocacy. If you enjoyed our program, make sure to subscribe, like, and share this post. The video for this episode is available on our YouTube channel with closed captioning and ASL interpretation. If there is a subject you would like us to discuss, please email podcast@drny.org or comment below. For more Empire State of Rights, follow us on Apple Podcasts, Spotify, and YouTube.